Hello and Assalamualaikum. Today, our group will be presenting about consent of children to medical treatment, a comparative study between Malaysia and United States of America.
Assalamualaikum warahmatullahi wabarakatuh. My name is NADHIRAH binti HASHIM. For the introduction, child means a person under the age of 18 years in relation to criminal proceedings, means a person who has attained the age of criminal responsibility as prescribed in Section 82 of the Penal Code Act 574. A minor is defined as one who has not attained the age of majority. Under the civil law, the age of majority is 18. The definition of a child or any provision fixing the age of majority under other written law may differ in accordance with the purpose of that law. In the United States, where the age of majority is set by the individual states, minor usually refers to someone under the age of 18, but can in some states be used in certain areas such as casino gambling, handgun ownership, and the consuming of alcohol to define someone under the age of 21. In U.S. immigration law, a child refers to anyone who is under the age of 21. According to INA 101 clause B clause 1 and 8 USC 1101 clause B clause 1, a child is defined as unmarried person under 21 years of age. Consent occurs when one person voluntarily agrees to the proposal or desires of another. It is a term of common speech with specific definitions as used in such fields as the law, medicine, research, and sexual relationships. Although this is indeed the legal or moral significance and effect of consent, the person who exercises the power to consent need not know or intend that by doing so, he is extinguishing a legal right he would otherwise have or is thereby releasing the actor from his duty. Rather, he only needs to satisfy the criteria of consent. The consenting person must of course be willing to permit the actor's conduct. That is what it means to satisfy the criterion of actual consent. But this is consistent with the person holding erroneous views of the legal effect of his permission. Article 12 provides that states parties shall assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. According to this article, no one shall be subject to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. This article was written in such a way as to place as few restrictions on children's participation as possible. It required that children's views should be heard and considered. For example, in Article 12 Clause 1, there is no limit for the children to be consulted. However, this article only guarantees the right to be heard for a child that capable of forming his or her views. Thus, the committee suggests to the states presume a child has capacity to form views broadly. Other than that, the committee discouraged states from introducing age limits for children's participation because the capacity were not determined by age. Capacity does not mean that child must be knowledgeable in all aspects in the matter of an issue, but instead by sufficient understanding the matters is already enough. The environment is very important in which children express their views matters. So, there is criteria that should be considered first. Venues that are not accessible or child-friendly prevent child's views from being properly heard. Maturity must also be observed as to the matter of issue because the greater impact on child's life, the more decision will be made and the more relevant assessment of maturity becomes. Then, if they want to properly exercise their right, the children must be informed that their views are heard by the committee, including information about the nature of proceedings and any potential decisions that may result. In conclusion, it can be seen that Article 12 Clause 1 have provided speciality for the children to raise their own views, and as for the matter of capacity will not again be a wall for them as they have a right to. Therefore, the children only have a right to exercise their right to be heard. They should not be forced to raise their views if that matters affecting themselves. Thus, there will be no more issues regarding the rights to their children in the future.
Hi, my name is NURDIYANA NABILAH binti RAZAK, and I will present about age of minor in Malaysia and USA. So, first we go to the age of minor in Malaysia. The definition of age of majority can be defined as the age of which the child legally become an adult. So, under Section 4 of Age of Majority Act 1971, it stated that the minority of all males and females shall cease and determine within Malaysia at the age of 18 years, and every such male and female attaining that age shall be of the age of majority. Thus, whoever that below than 18 years old is considered as minor. The age of majority was not included, which everyone always confused with other type of age such as voting age, marriageable, age of consent, legal working, school leaving, legal driving, smoking, drinking, and others. So, the definition of a child or any provision that fixing the age of majority under any written law may be distinct in accordance with the purpose of that law. So next, we go to the age of minor in USA. In the United States of America, as of 1995, minor is legally defined as a person under the age of 19 years old. The age of majority determined by states and not by law nor the federal, meaning each state can decide the age of the children became adults. Mostly in the United States, 18 is the most common age of majority among the states, and only Alabama, Mississippi, and Nebraska is 21 years old, which is the higher majority age. But some of the states recognize majority after they pass high school, meanwhile others have chosen at later age. However, such as violent crimes, the age at which a minor may be questioned as an adult is variable below the age of 18 or less often below 16.
Hello and Assalamualaikum. My name is NADZATUL EZZATI binti HISHAM. My metric number is 053063. So let's move on to the next topic, which is, can minor give consent to the medical treatment in Malaysia? The answer is no. Minor cannot give consent to the medical treatment. A patient who is under 18 years old and did not marry yet does not have the capacity to give valid consent to any medical treatment or surgery. The power to give consent will be given to their parents. Based on the provision of the Age of Majority Act 1971, a Malaysian will reach the adulthood age when they are 18 years old. Before the child reaches the age, they will be considered as a person who does not have a capability to give consent to his own medical treatment. Malaysia still does not consider a child have a capability to give consent by themselves. Can minor give consent to the medical treatment in United States of America? Most of the states in USA, the age of majority is 18 years old, and so, before treating a patient under 18 years old, they must obtain the consent from the patient parents or their legal guardian. Many courts in each state start to use the mature minor rule, where the minor can consent to the medical treatment on his own. This is because many states make an exception when it comes to the sensitive topic where parent consent is still needed. A mature minor means an adolescent younger than the age of majority. Such a minor can consent or refuse to consent to medical treatment if it is established that the minor is sufficiently mature to understand, discern, and appreciate the benefits and risks of the proposed medical treatment. Emancipated minor, which is mean the one who is legally free of parental control. A court ruling a marriage or enlistment in the US military for active duty are the most common scenarios. A minor who become a parent become the decision maker for the child. Now, most of the states have statutes that minor can give consent to the medical treatment.
Hi, Assalamualaikum. My name is Nurul Atirah binti ZAKARIA, and I will be presenting about divorced parents. Parents who are married share the right to make decisions on behalf of their minor children. For the divorced parents, their right to make decisions for their children are subject to the order given by family court. According to Section 3080 of California Family Code, stated that there is a presumption that joint custody is in the best interest of a minor child. subject to the provisions stated in Section 3011. Either parents or acting alone can consent to the treatment of his or her minor children, unless the court included language to the contrary in the custody order. Even if the consent of only one parent is required, it is clinically to obtain the consent of both parents. Withdrawal of consent is where one of the parents withdraws his or her consent after the commencement of treatment. If a parent has sole legal custody of the child, that parent has the right to unilaterally make healthcare decisions for the child. The second one is abortion. In the United States, most states typically require one of two types of parental involvement in consent or notification, or both. Parental involvement laws played a key role in forcing the court to clarify its position on abortion regulation. They are binding on minors, not adults. They require at minimum that minors notify their parents before an abortion is performed, and in some cases, consent from the parents. They allow minors to acquire a judicial bypass if consent cannot be acquired. But in Malaysia, getting an abortion is a risky and fatal business in Malaysia. Though legal, abortion comes with a heavy restriction in Malaysia. In Section 312 of Malaysia's Penal Code state that a termination of pregnancy is permitted only when there is a risk to the life of the pregnant woman or a threat of injury to her physical or mental health. According to the law, abortions are allowed to be performed by registered doctors in Malaysia. Socially, abortion is frowned upon in Malaysia, where majority of the population is Muslim.
My name is Nurul binti ROZALI. Organ donation. Living organ donation is an increasingly established practice. In the United States and Canada, LD by minors has occasionally been reported. LD by minors seem to be largely absent in the European Union. Minors can make autonomous medical decisions in the same way as adults whenever they are considered sufficiently mature to do so. In the United States, only the state of Michigan has enacted legislation that allows LD by a mature minor. A minor 14 years old older may donate a kidney to a close family member with prior authorization by the court. 11. The exception of Michigan, parental permission will always be required when LD by a minor is considered. By substituting the judgment of the minor or by focusing on his or her best interest, court has authorized kidney donation by minors to a sibling as a procedure or last resort subject to parental permission and donor assent. 13. In the United States, courts have not extended the mature minor doctrine to the context of LD. Comparing to Malaysia, the minor need their parents' consent to perform the donation. Parents' consent is rarely considered as a very important thing to perform any surgery, especially for a minor. In conclusion, it may be true that the implications of refusing treatment may be serious and perhaps even dangerous, but the same can be said of adults who refuse treatment. Once it is established that a child is competent and mature enough to have sufficient understanding to make decisions, what justifications are there for the parent overriding the decision of the child? Indeed, making a wrong choice is one of the consequences of judging someone to be competent and mature enough to make their own decisions. The decisions of competent children may be disguided, but again so may those of adults.
Thank you.